financial problems, elder law, tax problems, business matters, divorce, personal injury, bankruptcy, your life, your reality. Life is complicated. There is the law and there is reality. Welcome to Law and Reality, sponsored by Thav Gross. Now here's your host, Ken Gross.
Welcome to Law and Reality. This segment of the show, didn't hear the normal opening there. This segment of the show, we're going to talk about business divorce. And this is, and then from there, down the road, we're going to have a show, and a couple shows, we're going to just talk about the issues with regard to regular divorce, and we'll have a couple guests of divorce attorneys on. But on business divorce, this is something that we have the attorneys on.
It's funny.
David and I both handle business divorces on a regular basis.
It's funny that you should call it business divorce because when it comes down to it, the breakup of a business is similar to the breakup of a family unit in that the actual issues that you're going to deal with beyond in a family is custody and things like that would be money. And it's business divorce is all about
and custody of the assets.
Yeah, it's all about money and who gets what.
Well, typically you probably spend more time with your business partners than you do your own family and spouse.
Absolutely. What I always say is this, and a lot of times the conversation comes up with clients at the planning stage when they're going into business, and we'll talk about that a little bit more at the end. But one of the points that I often make is businesses are partnerships. They're like marriages. They have highs and lows, and they frequently fail. If you think about it, the likelihood of a business partnership lasting forever is unlikely. They typically don't last forever.
It's exponentially higher than the 50% divorce rate that goes across all socioeconomic and other metrics.
Absolutely. And what I always say is this, and this is what I've seen and experienced over the years. Sometimes a business comes together and it's extremely successful. And in that successful business, I see success breeding greed. And what happens is one partner or two partners say, hey, we're the reason for the success. Partner C is a slacker. He shouldn't get as much as we get. We got to get rid of C, and there's a grab for the chips on a successful situation. Then the other situation I often see is lack of success, and the partnership is floundering and failing, and I see that situation breed greed. And that's where, when things are falling apart, there is a scramble for the chips. The chips are all falling. Everyone wants to grab as many of the chips as they can before the business falls apart.
Well, it's all about me theory.
It's the greed is good.
Greed is good.
Gordon
Yes.
Gekko.
Gordon
Gekko.
We also typically see or have seen over the years the scenario where the expectation of who's going to deliver what to the common goal and partners or shareholders or members fall woefully short of what they promised at the beginning.
In fact, if you put a partnership together, whether it's an accounting firm, a law firm, any kind of a business venture, and you have 3 or 4 partners or more, and you sit down and say, these are the expectations of what everyone's going to do and contribute, the chances of that partnership functioning and the contributions being evaluated and saying they are what we anticipated across the board.
Same as the lotto.
Yeah, slim and nut, less than slim and nut. It's human nature. It's not going to happen. But let's talk about some typical cases. First one is I want to talk about when you have a partnership that's comprised of 50-50, 2 partners, very common, and it's what we call a 50-50 partnership. And I'm using the word partnership only in the context of 2 people coming together, not in the context of what form of entity they're operating. They might be forming a corporation, which could be a subchapter S Corp or a C Corp from a tax standpoint, or they might choose to operate as a limited liability company, which is also known as an LLC. They also have the right to operate as a partnership, quote unquote, but that's something that we would greatly discourage. Why is that?
Well, the law says in Michigan and throughout many areas of the country that if two people get together for a profit motive and lack of any other formations, they're deemed a partnership under Michigan law, a general partnership, which means all partners are jointly and severally equally liable for all debts of the entity, including contractual obligations, which are major things that you can protect. But
I was looking for a real simple answer to the
Actually,
question.
doesn't it really
You
just leave you exposed personally
gave me an
to
accurate answer, but
on your personal side? Because if there's no corporate entity,
I'd
your
like to
personal
just state
assets
it a
are
lot more
exposed.
simple for people that are listening or watching. If you're a partnership, you have unlimited liability for the debts and obligations of the partnership. Whereas if it's a corporation or a limited liability, you are not personally responsible for the debts of the corporation or the limited liability company unless you have specifically assumed those debts by signing a guarantee.
or you've acted negligently, etc. However, the point I want to make is many partnerships occur that are what we call de facto because people don't even think that they're partners, but if they're in business together, they're going to be deemed a partnership. But we use the term divorce when we're talking about this, and this is what I want to talk about real quickly, Ken, is most people don't enter into prenuptial agreements when they're getting married. Most people don't.
Correct.
Fair enough? And
Fair
I think it's that mindset when these businesses get together, they just get together because they're in the courtship phase, everything's great.
They should have
and
a
they
prenuptial.
don't have the prenup, and they don't have
what is the prenup?
shareholder agreement or the operating agreement.
Which is effectively, it would be effectively what we would consider to be a prenup for a business.
Right. So now if you took the
But it's
percentages,
even more than
if
that.
95% are going to fail or going to wind up in dispute, it's even more of a reason you got to have
Not only, but and it goes one step further than that. It's not because when we think of a prenup we're thinking of as being the document that identifies what happens if there's a breakup. A shareholder agreement or an operating agreement in a limited liability company is more than that. It doesn't just cover the breakup, it covers the go-forward operating rules of the business, how you're going to vote, what vote is required to pass certain things, certain actions do you need. Is one member allowed to borrow money from the company, or must all the members approve that type of an action, or must it be a unanimous vote or a majority vote? All of those issues get involved in what we call an operating agreement or a comprehensive shareholder agreement.
It's predominantly much more.
Right. Now, you jumped a little bit ahead of me on it, so I want to backtrack a little bit. You have a 50-50 partnership. You got two people, A and B, they're equal owners. You also have businesses that have more than two people, 3, 4, 5, 6.
Right.
As soon as you're beyond two,
No one has veto power anymore.
no. What do you mean by veto power?
If you're 50-50 in general, you could kibosh actions technically. Both of you have to agree. Now it becomes most likely, absent an agreement, who has the majority. Big difference.
Big difference, because as soon as you're getting to that situation, you need the agreement to rule what happens. We'll be back after the break and explain it a little bit further.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
We're Thav Gross. Our firm will solve your problem.
You like your job. What you don't like is the way your boss has been treating you. He's making comments about how you look instead of your work, and he's been touching you inappropriately. If you complain, is he allowed to fire you? Absolutely not. Unwelcome sexual comments, advances, and contact are illegal in the workplace. Make him pay. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, Dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
Every family has the family meeting, and we all know what that means. Dad's got dementia. What are we going to do? What's the care plan that the family has in place? Usually they don't, or they struggle with a care plan. When you go home tonight and you talk to your tax person and you talk to your financial person, say, what's the plan that you have in place? And as soon as they don't give you an answer, give me a call, because I can do it for you.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
We're Thav Gross. Our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
All right, welcome back. Let me do some quick announcements first. We've got seminar coming up. Go to our website is the best way to do it, or if you're watching the TV version, it'll be on the screen. Planning what decisions need to be made for 2015. Seminars are usually on Tuesdays and Wednesdays at our office from 7 to 8:30 p.m. If you want to sign up, just go to thavgross.com or lawandreality.com. There's a form right there. You fill it out. We're going to be focusing particularly in January. Focus is going to be on credit card debt because, from holiday spending, all of a sudden there's remorse that comes when those bills come. And, I got to tell you right now, if you've got $30,000, $40,000 of credit card debt and you're spending $8,000 a year after tax on interest, and you could come up with a strategy where that money went into an IRA or a 401k rather than to the banks that are getting your your interest, that's your retirement over 20, 30 years. So you need to take action. You want to sign up for the seminar, thavgross.com, lawandreality.com, or call 888-235-HELP. 2 free reports. Pat Simasko has a report, Retiree's Guide to Social Security. You can obtain that at ssifreereport.com. Also, How to Save Your Home with Regulation X, The Hidden Secrets. You can obtain that at regxhomesavers.com. You can also get both reports by calling our office at 888-235-HELP. I want to thank our sponsors, Gold Star Law, Simasko Law, Trips Auto Shop and Collision Center in Jackson and Lansing, U.S. Staffing in Jackson and Lansing, and Thav Gross. All right, back to the business divorce. And we were talking about an operating agreement or a shareholder agreement. This is an essential document, particularly in any kind of a business relationship of more than 2 people, because you don't have the veto power. You got 3 guys. If you don't have an agreement, the rule is majority rules. And in that case, 3 guys, 2 guys can gang up and fire the 3rd guy, terminate him as an employee.
So when you talk about voting,
her.
Having an agreement lets you sit down with the entire group that's investing in this and basically decide, okay, what issues, if any, are we going to have unanimity on? What are the big ticket items so each one of us are protected?
Like increasing salaries for the owners.
Selling the business.
Borrowing money. Selling the business.
Hiring and firing
buying
people.
a piece of equipment over $100,000.
Right.
Big, major material events.
Well, wait, I have a question then. So this shareholder agreement or operating agreement that needs to be done, it should be done with the members or the shareholders sitting there with the attorney. So you mean I can't just go do it on Zoom.com or 1-800 form my LLC?
You can go right online and just put shareholder agreement and Google it. You don't need to spend any money on Zoom, and you can get 1,000 forms. The problem is, what do you fill out in the form if you don't have the discussion and discuss the issues that can come up into play and point out to a group of see, if 3 guys or 3 girls are getting together forming a business, they're all friends and they're all excited.
We're all going to get along.
Everyone's
no
going to get
problem.
along.
We're going to work together.
But if you sit down in a meeting and you say to them, listen, based on experience, I'm going to tell you there's always bumps in the road. If 2 of you decide that you want to out the 3rd, Do you have the right to do that? Do you want to have a 2/3 vote, or should that be unanimous rule? And if that's the case, then what if somebody is slacking? How do you deal with that? You need to discuss those issues in a meaningful way. And unless you've,
Ken, there's the other big one.
unless you've been down that road and you're experienced with it, you need someone to guide you through it. And that's what a good business lawyer does.
And the other big one is, what if the business needs money? Who's going to put it in, and what's going to happen? And what if somebody doesn't have the money to put in?
Do they get diluted in their equity, or does it just or is the onus on the other shareholders just to loan the money? These are issues that come up. Now, you also get into the next issue that at a planning stage that you want to address, and it's buy-sell issues of if you're going to have somebody exit the partnership as a result of several different events, death, disability, termination of an employment, which could be voluntary termination or involuntary if the group decides to terminate the employment of one of the members. How do you deal with that issue? And there's a lot of issues that come up. You got valuation issues. How do you value the company? Can the company afford to buy the other partner out?
How do you resolve disputes? You could have a mechanism already determined, hey, if something comes up, we're going to do this. These agreements give you an
jumped
outline
ahead
and
on
a
the
framework.
outline.
What if you want to
wanted
add
to
another
mention-
partner?
I wanted
What
to
if you
mention-
want to bring somebody else in to
Those are good things, but why don't we mention some of the things that are right here on the outline that we've prepared?
Oh,
for
I
you
got
guys?
Rain Man. We got to go one at a
Covenants not
time
to
over
compete,
here.
Security. If somebody's gonna leave and you're gonna pay them, you need to get their covenant not to compete so they don't take the business and start competing against you. If you're going to buy somebody out and you're not paying them cash and you're going to give them money over time in the form of a note, do you also give them a security interest in the assets of the company? And do the other members guarantee those notes? These are all issues that need to be discussed.
And we haven't even touched what tax ramifications could come into play in planning,
And we're not going
which
to
we could
today.
do on a whole
Right.
separate show.
What's a shotgun provision?
Shotgun provision usually is, okay, I want to leave, or I want you to leave, and I go to you and I said, I'll buy you out for $1,000. And that immediately gives the other person the right to buy me out for the $1,000. So
An offer to buy is an offer to
so
sell.
it prevents a lowball.
But those are dangerous provisions that need to be thought out. Why? Because the guy who's wealthy is in a much better position in a shotgun situation than the one who is not.
So here's
you
a
have to be
question. You've
very
got all
cautious
these
about these types of
provisions that
things.
we're talking about that basically are setting up the divorce of the company. And my question that
Those are kind of the prenuptial provisions.
right. So my question is when you're dealing with people who are coming in to form a small business or a new business, are they likely to say, "Oh my God, I've got to put all these things in," or are they going to try and keep it simpler because it's a small new business and they don't know?
Some of them opt to just to ignore the issue and say, "I'm just not going to deal with it, and I'm going to move forward. I don't want to spend the money. I don't want to deal with it." Anyone who's sophisticated, who's been in business, and who's had a partner and is now starting another business, or who has the foresight to think through these issues and look at human reality, is going to say, I better address these issues, particularly if I'm making a significant investment in money and time in this venture.
Here's a quick question before we go to break. Can you fix it by adjusting the operating agreement after you've already...
You can, but you have to have everyone...
Later on down the
Everyone
road.
has to agree, and that can be a problem if at the time you're trying to fix it, there's hard feelings either way. We'll be back after the break.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
Worth Ave Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP.
Going from hourly to salary seemed like a good career move, but now you're working 60 hours a week instead of 40, and you aren't getting paid any of that extra time. You're stuck, right? Wrong. You can be on salary and still be entitled to overtime. If you've been wrongly denied such pay, you may be entitled to that and more. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
Every family has the family meeting, and we all know what that means. Dad's got dementia. What are we going to do? What's the care plan that the family has in place? Usually they don't, or they struggle with a care plan. When you go home tonight and you talk to your tax person and you talk to your financial person, say, what's the plan that you have in place? And as soon as they don't give you an answer, give me a call, because I can do it for you.
All right, welcome back to Law and Reality. We're talking about business divorce. And up until now, we've been going through kind of the planning stage. Now, let's go to this one. You have an existing business, and there's multiple partners, and they're in a fight. And they can't resolve it themselves. What can they do to reach a resolution?
And now this operating agreement is the mechanism by which, just making sure our audience
Why are we on the
understands.
operating agreement?
It lays out the
Here,
mechanisms
Brian,
which are
Brian,
available
Brian, let me help you. Okay, your operating agreement, for example, might have arbitration provisions.
That's what I was saying.
It might have certain. First, you got to look to whether there's an agreement.
So tell me what
I
you're going to
was
say.
just going to say the operating agreement is the first place you're going to look to find out what mechanisms are in place to resolve the
Fine.
difficulties.
The operating agreement is silent. They don't even have an operating agreement.
That's a problem.
You got multiple partners coming in. They've called me up. They've called David up. They've come into the Thav Gross, and one partner says, I got a problem.
Okay, the
I've
first
been
thing,
in business for 22 years with George. I liked him a lot 22 years ago. We were friends in high school. We went to college together. We formed the business. After 22 years, I hate George's guts. I can't stand the guy. He's a flaming jerk. He drives me crazy. He doesn't do his job. He's incompetent. He doesn't carry his own weight. He's taking out half the money of the company. He's taking the company credit card, and he's charging all this expense. He's taking his family on vacations and everything else. I can't stand the guy. I got to get rid of him. What do I do? David, what do I do?
You're 50-50 with George?
I'm 50-50 with George, and I can't stand the guy, and the company's making money, and he's going to bankrupt me unless I get rid of him.
Okay, well then, the first analysis you do is you determine whether or not
That's the issue.
You're at what they call in the law a deadlock. Because if you're 50-50, absent any other agreements, you both have veto power.
Yeah, we're at a deadlock
And
because
if the-
I want George fired, and he doesn't want to quit. I said to him, George, you're fired. George says to me, I'm not fired. You're fired.
Right. So then you got a couple alternatives. Number one alternative is if you're at a true deadlock and it's impeding the company's ability to conduct business, then you could
Can't
file
you
you could
see
file a
that
court
we are
action.
at a true deadlock where there's a lot of anger and hostility
Right.
here, a
You
little
can
role
file-
play here?
You could file a court action for deadlock and dissolution.
That's going to cost me a fortune.
If you're
How much do I have to pay you to do that?
Wait a minute. If you're a corporation, not as easy a question if you're an LLC. The law's a little bit unsettled there. So you got to first evaluate what type of entity are you. The bottom line is you got to
Before I go to court, is there anything else I can do?
Client comes in, you got to decide, can we get these guys in a room? Maybe we got to go to a facilitator, for example, to get in the room and to talk sense and say, guys, do you want to blow everything if it's a viable entity?
Now you're
Or
where
do you
I
want
want
to
you
go
to
to
be.
a mediator? Or it may or may not occur. So you got to look at what's going on. The issue is if you could get two reasonable people or two people that get reasonable advisors, you should be able to get a separation that's palatable. How you get there and what road you take is a dynamic thing that we can't necessarily cover in a show.
It depends, but here's the point. Here's the range of options. You can try and get the two partners, me and George, to sit down with some guidance, with maybe the assistance of the company's CPA for valuation purposes, the company's attorney. Sometimes we need to bring in a third party to act as a mediator to try and get the parties to carve out an agreement where one partner buys the other partner out. Here's the bottom line that people need to understand. if you just go at each other's throats, trying to strangle the other guy and kill him off,
You're cutting your nose.
what you will do is ruin your business. If you have bank debt and the bank finds out about it, they will call your loan. You have to be very careful and very smart and very level-headed in addressing the problem. If you can't resolve it through mediation or facilitation on an agreed-upon basis, there is litigation that can ensue. If it's a 50-50 company, it can be to liquidate the company. If you have more than a 50-50 situation where you have 3 or more partners, then you have the issue of one guy's trying to being forced out of the company, and you have minority rights litigation, what we call an appraisal remedy, where the guy who's being forced out has to sue to get paid the fair market value for his stock. Complicated litigation, same issues in play. You can spend a fortune in legal expense. You can jeopardize the integrity of the operation. You can jeopardize your relationship with your bank and your vendors by when the word gets out that there's a fight. You have to be smart in addressing these issues.
And don't underestimate the emotional aspect and the non-economic aspects that go into this. It's just like a divorce in the civil world, just like a divorce of a marriage or of two couples or a couple that's together. You have emotions that sometimes run much higher. Quite often, I would probably say the average corporation or partnership probably lasts longer than the average marriage. If the average marriage is 7 years or whatnot, the average.
We actually need to research that.
The average
I'm
the average entity that gets past probably the first 3 years is probably longer than the average marriage.
Except for a restaurant. No way to restaurant. Restaurants don't outlast marriages.
So the bottom line is
view.
you need to have, in my opinion, someone as an advisor that can be that reasonableness in your ear. Otherwise, you're going to spend a ton of money and potentially, as Ken says, devastate whatever is there that's good.
What I was trying to explain when I was giving my example with George is that's the passion that comes out when people are dealing with the problem. It's just like an individual divorce. A business divorce can be a nasty, difficult thing to go through. The planning stage of the operating agreement, shareholder agreement, that can cover valuation. It can create a pattern and a plan of how you get rid of somebody in a way that's fair to everybody. You also have to keep in mind, you don't necessarily want to become partners with the spouse of your partner. If your partner dies or becomes disabled, you don't want to end up typically being partners with the spouse. You need to have a buy-sell arrangement that properly values the company in order to terminate those relationships.
So you can legal zoom, but you may wind up in financial doom.
Oh, that was very
now
good.
I got to write
like
this
that.
down for the slides. Legal zoom will lead to doom. Have a great week. Thanks for listening and watching to Law and Reality. We will be back next week with Law and Reality.